you expect them to fulfill certain objectives, but you don't necessarily tell them when, why, and how to do that, then they are not considered an employee and don't fall into the employee exceptions that are in most farm liability policies. So I'm hoping that helps. Because that's pretty common, it's usually covered. But again, talking with your agent is the best way to go when you have those kinds of questions. Sometimes your agent doesn't always know what he or she has sold you, unfortunately, and it can be difficult to get really clear answers from them. I often tell farmers to try to do this in writing, because if you are dealing with an agent who doesn't necessarily understand the ins and outs of your operation, you might end up buying something that doesn't cover you, and you need some sort of fallback, some sort of evidence that you weren't sold the product that you asked to be sold. And in that situation, that gives you some ability to still get compensation if your policy doesn't cover what you thought it did. And somebody says, sounds like an independent contractor versus employee issue. Yes, generally your custom farming arrangements are independent contractors rather than employees, but the evidence on the ground would say. Okay, so back to this trading or buying in product. Once you do this, we have a couple of other rules and regulations that are popping up because of the concern about food safety that is growing around the country. The FDA wants to know if you are taking in product from other farms of more than half. So, and you have sales that are not necessarily direct to the consumer. So keep an eye on that. I do have a flow chart to help you understand if you may need to register with the FDA. It's free. And also the Food Safety Modernization Act. Many people have heard about this because the comment period recently closed. The Food Safety Modernization Act regulations are not yet in place, the specific regulations that apply to on-farm practices. They're still being written. But as things are panning out, farms, including CSA farms that take in other product, may be classified as a facility. Now, if you're a facility, there are several additional regulations you'll have to follow. So that's an area where you'll want to stay tuned, and an area where you'll want to try to manage the risks that may, the obligations, I should say, that may come your way under the Food Safety Modernization Act. It could be a year or more before we have a clue what that's really going to look like. Okay. Multi-farm collaborations, another thing I'm seeing increase around the country. I've got another story for you, of course. So let's say we have Farmer Joe, he does livestock, and Farmer Jane, she grows vegetables. And they operate their production separately, of course. They have separate land and they keep separate accounts, but they go in together to market to consumers. They have one brochure, one farm name, and when checks come in, they put them all in the same account. They don't ask folks to write two checks. And then they collectively set some financial targets for expenses. Jane's not going to exceed X and Joe's not going to exceed Y. And this arrangement works really well. And then pretty soon Sue wants to add, baked goods to the program. Let's say in this situation, we don't have any paperwork. Nobody signed anything. Nobody's discussed forming a business because it's, things are going fine. And it doesn't seem like we need to muddy the waters with paperwork at this point. But, of course, these legal issues crop up whether we want them to or not.